I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. In this video, we're continuing to talk about the EB-5 immigrant investor visa by focusing on the notorious source of funds requirement. Why notorious? Because for an EB-5 application, coming up with the money required for the visa is only half of the story. Convincing the government where you got that money from is oftentimes the most difficult part of the process. In this video, we'll take a look at the source of funds requirement and share some helpful tips to make the process a little less painful. Before we get started, please take a moment to subscribe. On our YouTube channel, we keep you updated on our firm's most current and trustworthy information about U.S. immigration, including options to visit, work, or live in the United States. You might think that the U.S. government would be eager to accept over $1 million from a foreign national who wants a green card, that they would roll out the red carpet or at least make the process fast and straightforward. But that's not the way it works. Before the government will accept your EB-5 investment, they must be convinced that the money came from a lawful and legitimate source. We call this the source of funds requirement. This applies not only to the required investment amount of $1,050,000 or $800,000 for a targeted employment area, but starting in 2022, the source of funds requirement also applies to any money that was used to pay administrative costs and fees related to the investment. So if you invested $800,000 into an EB-5 regional center project, paid an administrative fee of $50,000, and paid legal fees of $10,000, you'd need to account for exactly where you got not just the $800,000 investment amount, but the total $860,000 that includes those administrative and legal fees. Now, fortunately, as long as the source of the invested funds is legal, applicants have many options in terms of where they can get the funds from. For example, money that was gifted from a friend or a family member can be acceptable, as can proceeds from a loan, as we've discussed in an earlier video. Similarly, funds generated by a business that the applicant owns abroad can be acceptable, as can money the applicant earned by working abroad. Another common source of funds is the sale of real property, such as an apartment. In terms of what is not allowed as a source of funds, this would include any funds that are not actually owned by the applicant. The applicant must be the legal owner of the invested funds. Also, as we discussed in a separate video, any loans that are secured by the EB-5 business or its assets, and any funds that result from a debt agreement between the EB-5 business and the applicant will not be considered. So let's assume that the funds that were invested were received by the applicant in a way permitted by USCIS and that they were acquired lawfully. What does USCIS expect to see when it comes to where the invested funds came from? The requirement in the Immigration and Nationality Act is that any funds used to satisfy the EB-5 investment requirement or to pay any related administrative costs and fees must be obtained from a lawful source and through lawful means. In other words, the government needs to be convinced that the funds were not acquired illegally. The EB-5 Reform and Integrity Act, which was passed in 2022, added language to the Immigration and Nationality Act that defines what documents the government expects to see. Among other things, that law says that the government can require any evidence identifying any source of capital or administrative fees. That's very broad. In practice, the documents USCIS will require are case-specific, meaning that they will be different depending on the source of the funds. This makes sense, since documents showing that the applicant received the funds from, for example, the sale of an apartment will look different from documents showing that the applicant got the funds through a loan from a bank. So how can you approach providing enough documentation to satisfy the source of funds requirement? In general, the applicant will start by first identifying where the funds are from. Then they'll list all the documents that prove that the funds came from that source or sources if there was more than one source. Generally, if the source is an asset, such as a business or a piece of real property, think about documents that prove who owns the asset. If the source is a job, think about documents that prove employment and the amount paid, such as payroll records. Also think about documents that prove the movement of the funds, such as bank statements and wire or transfer receipts. Think about other documents that prove the receipt of funds, such as tax returns. After listing out all the documents that show the source of the funds and how they moved from the source to the applicant, you'll need to actually collect those documents since the government will want to see them, and they will not take you at your word alone. So let's take an example. If the invested funds are from income the applicant earned from a foreign business that they own, the applicant would first want to prove that they do in fact own the business. For this, they'd submit foreign business registration records. To prove that the business actually distributed funds to the applicant, they'd gather foreign business tax records showing income and distributions made by the business, transfer receipts showing that funds moved from the business to the applicant, and they'd also get the applicant's personal tax return showing that the applicant paid taxes on any funds that they received from the business. To take another example, if the funds are from the sale of an apartment that occurred a couple years ago, the applicant would gather the sales contract, a copy of the deed, transfer receipts, and bank statements showing that funds were paid to the applicant in exchange for the apartment, and personal tax records showing that the applicant paid taxes on the proceeds from the sale. Hopefully with these examples, you're starting to get a sense of how to think about how to get documents proving where the funds came from, and how they moved from that source to you as the applicant. But what if you got the funds as a gift? The applicant must then provide documents proving that the person who made the gift got the funds legally. If the funds were gifted to the applicant would need to demonstrate exactly where the person who gave them the funds got the money. For example, if the person who made the gift got the money from selling their apartment, the applicant would need to provide the documents I mentioned before, proving that the source of the funds was in fact from the sale of the apartment, and that the person making the gift then transferred those funds to the applicant. After establishing the source of the funds, the applicant must show the transfer of the funds from the source to the EB-5 business. Continuing with our example of the applicant who received the funds as a gift from someone who sold their apartment, the applicant would submit documents such as transfer receipts and bank statements showing that the funds moved from the person making the gift to the applicant, and then from the applicant into the EB-5 business. According to the 2022 EB-5 Reform and Integrity Act, USCIS will also require additional documents. These include documents related to any court proceedings or judgments against the applicant that involve possible monetary judgments against them, whether the proceeding is administrative, civil, or criminal, and regardless of where the proceeding happened, whether inside or outside the United States. These documents also include documents demonstrating the identity of anyone who transfers funds into the U.S. on behalf of the investor. One question that comes up a lot in this discussion is how far back in time the government can look to determine the source of funds. For example, it's easy to imagine proving the sale of an apartment 2 years ago. But what if the apartment was sold 40 years ago? Unfortunately, the government's position is that there is no limit on how far in the past USCIS can require documentation. USCIS can and does ask for documents about the source of funds that go back decades. That being said, USCIS's authority to require supporting documents is not without limit. First, the regulations place a 5-year limit on tax returns and a 15-year limit on administrative, civil, or criminal actions. Also, although you as the applicant bear the burden of proving that your application should be approved, the standard you need to meet is that it must be more likely than not that your claims are true. In other words, as stated in the USCIS policy manual, even if there is some doubt, if the applicant submits relevant, probative, and credible evidence that leads an officer to believe that the claim is probably true or more likely than not, then the applicant has satisfied the standard of proof. In other words, you don't need to prove with 100% certainty where you got the funds. You only need to convince the government that it's more likely than not that you got the funds from where you say you did. But what if the documents showing the source of funds don't exist? For example, what if you simply don't have the sales contract from that apartment from 40 years ago, and the bank doesn't retain documents going back that far either? The first step is to consider secondary evidence, such as articles or listings in local newspapers that speak to the event, in our example, the sale of the apartment. The government might also accept affidavits, which are written statements by someone with first-hand knowledge of the relevant information. The statement is signed under oath and usually notarized. In our example of the apartment sale, the applicant might provide an affidavit from the lawyer who oversaw the sale or the bank that transferred the funds. If you can't get any affidavits, USCIS might be willing to accept evidence that the documents are not available. For example, again going back to the apartment sale, you might get a written and signed statement from the bank stating that the requested documents do not exist and why. For example, it might be that the bank has a retention policy requiring that it destroy documents that are more than 7 years old. You might include in your application a statement explaining that. If it's also not possible to get such a letter, your final option is to submit evidence showing your repeated attempts to get the required documents. This can include letters, emails, and notes from phone calls you make to the bank, for example, in an attempt to get documentation proving the source of funds. While this is a last resort and might not be sufficient in the eyes of USCIS, it's usually better than providing nothing at all. When you're struggling to get supporting documentation showing the source of your invested funds, it's important to think broadly. Is there any documentation at all that shows the source of funds? Is there anyone who was there and can speak about the transaction? This is a good time to be creative and to document all of your attempts to get the documents. The source of funds requirement really is one of the more significant hurdles in an EB-5 application, but with diligence and some creativity, it's a hurdle that can be overcome. We hope this video about the EB-5 source of funds requirement was helpful. If it was, please click the like and subscribe buttons to stay updated on future videos about visa options and travel to the US. Thank you for watching.